So, hello everyone, and thank you for joining today's session. My name's Richard Demery, and I'm from Homes England. So I'm delighted to welcome you to our summer learning programme. And this is a series of knowledge sharing sessions on topics that we have been told are of interest to you and our wider community. So today's event is Environmental Impact Assessment, the Basics, and this has been delivered by Litchfields. So the Summer Learning Programme has been brought to you by Homes England's Local Government Capacity Centre, and the topic of this session is an important focus in Homes England's new strategic plan. So on the screen there, you'll see Homes England's new mission. So this is all about creating high quality homes in thriving places that people are proud to call their home. And along with this new mission, there's a number of new strategic objectives. So this topic, environmental impact assessment, is really supporting the one on the bottom. You can see there about enabling sustainable homes and places. So this slide just generally says there's five objectives. This topic is really supporting the bottom one there. So next slide, please. So here we have on the screen here a summary of what the Local Government Capacity Centre are. So Homes England established this centre following extensive research and consultation across local government and with a wide range of other partners to determine where authorities most needed support and how this can be delivered. So sessions such as these help deliver that support. We look forward to hearing how we've done in our polls at the end of the session. So let's have a look at the agenda for today. So we've done the welcome and context of the session. So there'll be a number of sessions. There'll be an introduction from Nikki into Litchfields, and then we'll have three presentations. First of all, starting with environmental impact assessments from Heather. We'll have a session from Gail on a recent case study, expert thinking and case law, and then Nikki will round off the presentations with a which way now. So the future of where it's going. Then we'll follow that with a question and answer session. So I hope you've taken all your questions that you've popped in the chat throughout the presentations. And then we'll close it off roughly around 12:25, 12:30. So hopefully you'll have a good session and improve those 2s and 3s up to maybe some 4s and 5s. But hopefully see that at the end. So I'm now going to pass you over to Nikki, who will give a brief introduction into Litchfields. Thank you.
Thanks, Richard. Good morning, everybody. My name's Nikki Meggleston. I lead on EIA at Litchfields, and with my colleagues Gail and Heather, we all form part of the EIA team. I think we've set ourselves quite a bold challenge this morning with the title Understanding Environmental Impact Assessment, but don't worry, we're not going to be here for the rest of the week. What I just try and explain what we're planning on doing over the next hour. We work for both private sector clients, coordinating environmental impact assessments, and also for the public sector. That's both assisting decision makers in the choices that they need to make as to whether an EIA is needed, what goes in it, how you then determine that, and also for public sector clients who are delivering on the ground. And I think we observe that EIA is often seen as a bit complicated, quite problematic, bit of a dark art. And I think what we would like to try and do over the next sort of 45 to 60 minutes is try and demystify some of those issues and help you with the next time you're faced with an EIA, whether that is as an applicant or as somebody who is deciding whether or not one is required, what needs to go in it, and how you determine that. Next slide, please. So I think as Richard's outlined, this is what we're hoping to cover. So first of all, Heather is going to go over the basics. Obviously, we've got a number of 2s and 3s. I think there's obviously a little bit of knowledge about EIA, but I think Heather's going to go through the basic stages of the process and what it means for you as applicants and also determining authorities. Gail will then very much do a kind of troubleshooting guide using a case study, applying the principles of EIA to developments, looking at processes such as what you would need to do if you need to supplement it, and the mitigation and delivery of projects as they're sort of brought forward where an EIA was necessary. And then what I would like to try and do is then just wrap that up, picking up on the proposals that were issued in March this year by Department for Levelling Up, Homes and Communities, on new proposals for how EIA might move forward in England, and some of the key issues that we know that you're all facing, and some suggestions about the sorts of things that you might want to think about in dealing with EIA. So without any further ado, I'll pass over to Heather.
Thank you, Nikki. Hi, everybody, and welcome again to our presentation on EIA. My name's Heather Overhead. I've been a senior planner here at Lichfield for about 4 years now, and prior to that I was a local authority planner for about 10 years. Next slide, please. So as you can see, I'm going to cover the basics of EIA. We're going to start by looking at what EIA is, and then we're going to run through the stages in EIA, taking us up to the point of the decision for the planning application. Next slide, please. So what is EIA? Well, it's a process which consists of the preparation of an environmental statement, which we usually refer to as an ES. It's consultation and publication, and it's also consideration of whether planning permission should be granted. It's important to differentiate between EIA, which is this process, and the environmental statement, which is a report of the outcome of the assessment at a point in time, and this must be used in the decision-making process. So the EIA must identify, describe and assess the significant effects of the development on the environment. And you can see there in the diagram the different aspects of the environment that need to be considered. Next slide, please. Okay, we'll just take a brief look at the legislative context, as after all, it's why we do EIAs. EIA has its roots in Europe, starting with the 1985 directive. There have been various updates to this, culminating in the current 2014 directive. These directives have formed the basis of the EIA regulations across the UK, and the most recent English EIA regs are the 2017 regs, and these were amended in 2018. Just a note on Brexit. The Brexit regulations have ensured the continuity of the legislation now that we've left the EU, so the regs are still in place and active. And you may well have heard about the recent consultation from government on an alternative form of environmental assessment called environmental outcome reports. This is something that Nikki's going to cover, but at the moment is not in place. Next slide, please. So the first stage for a development is to consider whether it meets the definition of EIA development, which is provided up on the screen. There are 3 categories of developments which may require an EIA, and these get their names from the schedules in the back of the EIA regs. So we start off with Schedule 1 developments. These are the most polluting or largest schemes and include things like nuclear power stations, long-distance road and railway schemes and airports. And Schedule 1 developments are always EIA development and will therefore require an environmental statement. Moving on to Schedule 2 developments. So Schedule 2 takes the form of a table. In the first column of the table, it lists different types of development, and then in the next column, there are different thresholds. And if the thresholds are exceeded, then the development is a Schedule 2 development, and it must be screened to determine whether it is EIA, and we'll come on to that. Just to give you an example of the thresholds, if we're talking about housing, there are 3 thresholds to be aware of. The first is the number of dwellings, so if the scheme is over 150 dwellings. Secondly, we have 2 different site area thresholds. In an urban area, the site threshold is 1 hectare, and outside of the urban area, the threshold is 5 hectares. Third category we have to consider are exceptions. These are schemes which don't exceed those thresholds or are not listed in the Schedule 2 types of development, but they may still have significant effects. So, for example, we may have a scheme for a 20-storey tower block on a very small site in an urban area, and this could have significant effects on the local townscape. Next slide, please. So the process for determining whether a development is EIA development is known as screening. And this really only applies to Schedule 2 developments and exceptions. And local authorities have a duty to screen all Schedule 2 developments to determine whether they are EIA development. And this happens generally in one of two ways. Firstly, through the submission of a screening request, by which an applicant will ask the local authority to formally determine whether the development is EIA development or not. And secondly, through the submission of a planning application for Schedule 2 development. When a local authority receives a planning application for Schedule 2 development, they must screen it to determine whether it's EIA. So when taking that decision of whether a development's EIA, local authorities must consider the information in Schedule 3 of the regs. Firstly, they must think about the characteristics of the development. For example, is it a particularly large development, or does it have particularly polluting outputs? Secondly, authorities must consider the location of the development. Is it close or within sensitive receptors? Sensitive receptors refer to the things that could be affected by the development. It includes people, ecological sites, heritage assets, and many more. Thirdly, we need to consider the types and characteristics of the impacts likely to arise from the development. We need to think about the nature of the effects, the magnitude of those effects, their duration, and whether they're likely to arise. It's important to note that you can take mitigation into account in your screening decision, but there's a lot of case law around this, which states that you must have sufficient evidence of the potential impacts and the effectiveness of the proposed mitigation. So you really need to know what the specifics of the mitigation are and how they can be secured on any planning permission. Now, we do understand screening is quite a tricky issue. There's no single definition of what a significant effect is. And we would encourage you to look to the PPG, the Planning Practice Guidance, for pointers. There's an indicative thresholds table in there, which adds meat to the bones of the Schedule 2 thresholds. And there's also a screening checklist that runs through a series of questions of things you need to think about when you're thinking about whether significant effects are likely. Next slide, please. So the local authority will issue their decision in a screening opinion, and they have 3 weeks to do this, either from receipt of the screening request or from receipt of the planning application. The EIA regs are very clear on what the screening opinion must consider and what it must include. And it's important for applicants as well as local authorities to be aware of this. It's important to make sure you review any screening opinion you receive and make sure that it's robust to avoid any legal challenge further down the line. So a screening opinion must state the main reasons for its conclusion. It must state any features or mitigation that it relies upon to reach its conclusions, and it must specify the mitigation measures and how it will be secured. Importantly, it must be issued by somebody with the authority to make EIA decisions in the authority's scheme of delegation. Next slide, please. So once it's been determined that a scheme is EIA development, the next stage is called scoping. And this is the process for setting the scope of the ES, the environmental statement. It's a voluntary process by which an applicant submits a scoping request to a local authority to get their formal view on the scope of the ES. Now, the scope of the ES includes what topics will be covered, for example, transport, ecology, landscape and visual effects, and many more. You only scope topics into an ES if there is potential for significant effects to arise in relation to that topic. Other topics can be scoped out and dealt with through normal planning application process. The scope of the ES also includes the receptors, those things that might be affected by the development. And again, we could be talking about people, heritage assets, habitats, and many more. And then finally, the scope of the ES includes the methodology. How will the assessments be undertaken, and how will significance be judged? Local authorities have 5 weeks to issue their scoping opinions, and any ES prepared subsequent to that must adhere to the scoping opinion. Now, as I mentioned, it's a voluntary process, and we're often asked whether it's worth it. And in our view, it is. The pros certainly outweigh the cons. In terms of the pros, it's a really useful information gathering exercise and provides a route into engagement with both the authority and the statutory consultees. It provides a real focus for everybody on what the real significant effects might be arising from the development. It helps in the evolution, the design evolution of the scheme. And at the end of it, there should be clarity and certainty for all parties on what will and won't be covered by the ES. In terms of the cons, we do understand it's a free service for local authorities. There's no fee attached to it, and it does take time and resource. However, developers tell us that they are willing to enter into planning performance agreements and pay for the scoping process as part of the general pre-app process. So as an authority, if you're under-resourced, think about whether you want to outsource your EIA services. We're seeing more local authorities do this up and down the country. Next slide, please. So the EIA regs are very clear on what a scoping opinion must have regard to. By and large, these are the same kind of things that a screening opinion must have regard to, but importantly, it should also consider and include any consultee responses. The scoping opinion should be very clear on which topics are scoped in and out. It should be very clear on any mitigation relied upon to scope topics out. And once again, it should be issued by someone with the authority to make EIA decisions. Next slide, please. The next stage for a project in the EIA is the preparation of an ES. So all applications for EIA development must be accompanied by an ES, which is the reporting mechanism for the outcome of the assessments. The EIA regulations require that the ES must be prepared by the applicant using competent experts. It must include the information set out in Regulation 18 of the regs and Schedule 4, and if relevant, the scoping opinion. Case law tells us that it must be prepared as a comprehensive document, not as a series of disparate reports. Next slide, please. So as I said, the EIA regs set out the information that should be in an ES. It should include a detailed description of the development, and this must cover the whole of the development over the whole of its lifetime, starting with any demolition and site clearance, going through construction, operation, and if relevant, decommissioning phases. There may be overlap between these phases. It's not unusual to have construction happening on one part of a site while other parts of the site are operational, and this must be considered and assessed in the ES. This description must provide clarity on what's assessed in the ES, and this is something that Gail is going to talk about in more detail in her presentation. The ES must very clearly identify any mitigation relied upon in the assessments. Now, mitigation means measures to avoid, prevent, or reduce any likely significant effects. Mitigation can be embedded, by which we mean measures built into the scheme. So that might be building heights or a landscaping scheme. And mitigation can also be additional. Additional mitigation usually requires further information to be secured by condition. This might be, for example, the submission of a detailed lighting plan, which demonstrates how certain lux levels will be met. Effects in the ES should be assessed alone and in combination. So firstly, in combination with each other. You may have a group of residents who will be subject to visual impacts, noise impacts, and air quality impacts. Individually, these impacts may be assessed as not significant, but when they're happening all together at the same time on the same group of people, they may become significant, and it may be necessary to think about how those impacts can be mitigated. Secondly, effects must be considered in combination with effects from other developments coming forward in the area. You may have two sites fairly close to each other with schemes coming forward at similar times, and it's important to consider whether the combined effects of those might produce significant effects that wouldn't be identified in either of the individual ESs. And then finally, it's really important that an ES includes a non-technical summary. As the name suggests, this is a summary of the information in the ES, and it has to be produced in non-technical language. Next slide, please. So as many of you will be aware, ESs vary enormously by both their quality and their length. And so what makes a good ES? Starting point for considering this question is to think back to the purpose of it. The purpose is to inform the decision on the planning application. It needs to be read and understood by a range of audiences. You obviously have the case officer, but you also have consultees, members of the public, and councillors. All these people need to be able to read and understand the ES. To help with that process, it's important that the ES uses consistent terminology throughout and a consistent way of defining effects. It's not very helpful if one chapter refers to a slight adverse effect while another chapter refers to a minor adverse effect. It's also important that there's consistency in the assessment of mitigation. So if the noise chapter identifies the need for a bund, then the landscape and visual impact chapter should assess the visual effects of that bund. We think it's really useful to draw all the mitigation and monitoring measures identified in the different chapters together in a single chapter at the end. We think this provides a useful list for the local authority determining the application of measures that might need to be brought forward onto the decision notice, and it's also very useful for the applicant to see the list of measures they're signing up to all together in one place. In our ESs, we also think it's useful to draw together conclusions into a single chapter, which makes it easier to identify in-combination effects. Finally, it's really important that the NTS is a clear, concise document which draws out the key features of the scheme and the outcomes of the assessment. This document is often the first place that people look when receiving an ES, and a good starting point for members of the public. Next slide, please. So once a planning application within ES has been submitted, there are slightly different timescales and publicity requirements to those for a normal planning application. So EIA development is subject to a 16-week determination period instead of the usual 13 weeks for a major development. There are different publicity requirements, and in terms of consultation, consultees have 30 days to respond instead of the usual 21. If the local authority considers that further information is required to determine the application, they can request that under Regulation 25 of the EIA regs. Once that information is received, there's another 30-day consultation period before the authority can make their decision on whether to grant planning permission. Next slide, please. Okay, so if you remember back to the definition of EIA, it's a process, and the final stage in that process is consideration of whether to grant planning permission. The EIA regs set out what the decision maker must take into account. They must examine the information in the ES, and they must then use that information to reach a reasoned conclusion on the significant effects of the development, and they must integrate that conclusion into their decision on whether to grant planning permission, with a consideration of whether it's appropriate for any monitoring measures to be secured by condition. That's the end of my presentation on the basics of EIA. Thank you for listening, and I'll now pass over to Gail, who'll talk through the key principles used in EIA.
Thank you, Heather. My name's Gail. I'll now take us through an EIA case study, some expert thinking and case law. Next slide, please. So I'll start with an explanation of the term the Rochdale Envelope, and then I'll move on to how this was adopted within our case study. I'll go through some basic principles and approaches in EIA, including some post-consent matters. I'll discuss how EIA mitigation interacts with the decision making and when you might need to consider supplementing the environmental statement. And I'll include an explanation of salami slicing and how we define the EIA project. Next slide, please. So how do we test the development in EIA, especially when we don't know the precise final details or the precise layout? And this is usually the case when a developer wants to submit an outline planning application, where they perhaps want permission for some details but leave other aspects of the development until a later stage in the process. So the Rochdale Envelope has been coined from two cases, which related to outline planning applications for a proposed business park in Rochdale, hence the name. So it applies when you need to test parameters rather than a fixed form. The parameters are then presented on plans, and I'll show you this on our case study. So the Rochdale judgment provides some pointers. It says that you should assess the worst case. The level of information should be sufficient to enable the main or the likely significant effects to be assessed, and the mitigation should be described and it should be adequate. However, the developer should not abuse the need for flexibility. There's no excuse for inadequate descriptions of the development, and the decision maker needs full knowledge of the likely significant effects. If there's any uncertainty about what those effects might be, or there's not enough information, the decision maker needs to ask for further environmental information to be provided. Next slide, please. So this is our Midlands case study, and this relates to a hybrid planning application. And what we mean by this is the developer sought detailed planning permission within the application for a Southern Link road, and they wanted outline planning permission for the rest of the development. And this included over 4,000 homes, 13 hectares of employment land, local and district centres, schools, sports facilities and open space, and a northwest link road. So unlike the Southern Link Road, they wanted outline permission for the northwest link road. So I'll now run through how the Rochdale principles were applied in our case study. So next slide, please. So this was our first parameter plan on this project. And a parameter plan essentially defines the maximum and the minimum extents of development. And in this example, each parameter plan was also very helpfully accompanied by a page of explanatory notes. So on this plan, you can see the red line boundary defining the outline of the site, and you can also see the yellow shading. So this plan's quite simple. The yellow shading denotes where built development was going to go, and the white shading is where there should be no built development. And we use this because it ties in really nicely with the definition of development within the Town and Country Planning Act. And so it was clear that by built development and development, we didn't just mean houses, but we also meant things like substations or pumping stations or drainage infrastructure. Next slide, please. So this was our density plan. Again, quite easy to understand. The darker the colour, the higher the density of the development. There was also a little bit of flexibility provided within each zone, and this was explained in the notes. However, the purpose of the environmental assessment was obviously to assess the effects of this plan. And what came through from the design evolution stage was some of that flexibility and the density wasn't appropriate in particular places. So you'll see that in the northern and eastern extents and also around the existing residential development, there is some hatching on the plan. And this was where the developer decided to remove that flexibility and density. And the purpose of this was to try and reduce some of the environmental effects. And principally in this case, it was to reduce the landscape effects and the heritage effects. So when you're faced with a development and you think that you might want the developer to make some amendments or to restrict the development in an extra way at a particular location, think about whether you can use the parameter plans and annotations on the plan to help control and restrict that development. Next slide, please. So this is our building height plan. Again, really simple. The darker the colour, the higher the buildings could be. And I'll not labour that one too much. So next slide, please. So this was our access plan, and this one is slightly more complicated. So within this plan, the shaded area at the bottom of the plan, that denoted the detailed part of the planning application. So it essentially signposted the viewer to go and see the detailed plans. And when it came to the ES, anything within that shaded area, the assessments used the detailed plans as the basis for their assessment. So the blue hatching set the principle of a link road. So the blue hatching that runs through that sort of central swathe of the site, that was where essentially the developer was saying, I will provide a link road It will be within this broad area, but I'm not quite sure where the precise location will be and what the precise design of the road will be. And we'll worry about that at the reserve matter stage. But ultimately, this plan enabled the principle of a road in that location to be tested within each of the different assessments within the EIS. You'll also notice on this plan that there's a series of numbers, and these denoted pedestrian and cycle links between different points of the site. So what the plan was doing here was securing the sustainability, so the principle of cycle and pedestrian links from particular points, but allowing enough flexibility for the precise alignment of those links to be provided at a later stage. Next slide, please. So this is the land use plan. The very light green obviously marries up with the development zone that we saw in yellow on the first plan. And the blue hatches relate to the local and the district centres and the broad location that those local and district centres could come forward in. Again, we use some notes, and the notes define the different uses and the different quantums of development which could come forward and sort of set a certain area of floor space for shops and services. It also set the size of the sites for the schools. So the annotations and the plans essentially help to secure the sustainability of the site and help to ensure that the socioeconomic benefits of the development were delivered, but without having to specify the precise detailed layout at the point in time of the outline environmental statement. Next slide, please. So this is our final plan, and it's the landscape infrastructure plan. And this plan sets out the different types of green infrastructure to be provided, and it includes amenity, green space, sports pitches, and allotments. And again, there was some notes specifying quantums and definitions of particular types of space that needed to be provided to make the scheme acceptable. Also on this plan, and crucially, there was some embedded mitigation included. In the dark green circle denoted a woodland copse on a ridge, and there was also extensive tree planting around the edges, and this helped ensure a tree-dominated skyline. All of this was then relied upon within each of the assessments to reduce the landscape and the heritage effects of the scheme. So that's a bit of an overview as to how we use the Rochdale envelope within our case study. And I'll now move on to mitigation in the EIS in a little bit more detail. Next slide, please. So if an application has an environmental statement, use the environmental statement to decide the terms of the decision notice. So to do that, you need to understand what has the environmental statement tested. So most EISs have a clear description of development chapter, and it will set out in a lot of detail exactly what plans have been tested within that environmental statement. Now that could be a description of the detailed plans, a description of the parameter plans, or a description of strategy and principle documents. So that could be a sustainable drainage strategy or a green infrastructure strategy. What that chapter should also be doing is describing any mitigation which is already on the plans. So be really clear at the end of that process, and after reading that description of development, you should have a really clear idea as to what exactly is being applied for, what has been tested in that EIS, and the assumptions that have been made for the assessments. Next slide, please. So where else do you need to look in the environmental statement to understand the effects and the mitigation proposed? Well, each technical assessment should clearly identify the mitigation that it's relying on. So sort of back to our previous example, there may be a landscape buffer proposed, and that landscape buffer is either on the detailed plans or the parameter plans. But that isn't sufficient to completely mitigate the effects. It kind of follows that there should be a management plan which will help maintain that landscape buffer during the lifetime of the development. So look for two elements. Look to see if there is mitigation, but also some management and monitoring of that mitigation. Now, as Heather's mentioned, each EIS has its own structure, and within Litchfields, we like to prepare a concluding chapter on mitigation. And we see this as essentially a one-stop shop. It hoovers up all of the mitigation which has been identified in each of the technical chapters. It sets out how that mitigation will be secured, and it also provides key aspects so that the detail on the mitigation is sufficient. This then helps ensure that the mitigation meets the conditions test, so particularly in relation to necessity and preciseness. And then we also go on to consider if monitoring is needed to make the mitigation effective. Now, we do this to help the developer understand what they need to agree to when it comes to delivering the development. But we also do it to help the decision maker and the local authority write the terms of the planning permission. Essentially, the conclusions of that mitigation measure is the bare bones of your decision notice if you're determining to grant consent. Next slide, please. So just a final point on mitigation and delivery is to be wary of the pretty pictures. So often a developer will prepare illustrative material. Now that could be an illustrative master plan or a design and access statement. And those plans and documents can be really helpful to help you understand in practice what the parameters might look like and what the development might look like at a later stage. However, what the developer is essentially saying by marking it as illustrative is, I might not ultimately deliver it like this. So the environmental statement should not be testing anything that is illustrative. It should only be testing the plans that the developer wants planning permission for. If there is anything on those pretty pictures which you as the decision maker are relying on and you feel are needed to mitigate the effects of the development, they need to be added onto a parameter plan or a detail plan or secured by condition. Also check that none of the consultees are referring to the pretty pictures and the illustrative material when they are providing their consultation response. So like I say, just at the end of the process, do a real check of the illustrative material and just make sure that anything that you need to be secured is on a plan for approval or secured by condition. Next slide, please. So once a development is EIA development, all subsequent applications stemming from that permission are also EIA development. By this, we mean discharge of condition applications, reserve matters applications, and any variations which are carried out by way of a Section 73 application. So the question you need to decide is there a need to supplement or amend the original EIS to deal with the effects arising from that subsequent application? The number one question to ask yourself is the original EIS still fit for purpose or does it need to be updated? So types of things to consider are, is the development different? Are there changes to the scheme phasing or changes to mitigation which might affect the conclusions of that original EIS and mean that they're no longer up to date? Has the site or the local environment changed? Is there any new surveys which have been undertaken? And if you use the results of those surveys, would that have changed or given rise to different effects than originally set out? If the answer to those questions is no, then a supplementary EIS or an addendum EIS isn't needed. Next slide, please. So if the original EIS doesn't need to be updated and it's deemed to be fit for purpose, it is worthwhile considering, if you're the developer, whether you rescreen that application or whether you prepare a compliance statement for that subsequent application. And this was an approach that we adopted in our case study. A house builder for one of the phases was bringing forward a reserve matters application, and we prepared a compliance statement. What we did in that compliance statement, and the process is quite similar, whether you're rescreening or you're preparing a compliance statement, is to essentially set out why the EIS, as previously drafted, assesses the effects of the development that's now proposed. And we did this with a topic by topic review of the detail of the original EIS and what was assessed in that, and comparing that with what was now proposed in the reserve matters application, and comparing how the effects and the mitigation were deemed to be the same as originally set out. So what do you do if it does need to be updated? Well, if the change would result in different effects, then you need to prepare a supplementary EIS to sit alongside the original EIS. Now, the scope of that supplementary EIS is really dependent on the change. So it does not follow that the entire EIS needs to be updated. Think about the change and what's relevant to it. So, for example, a change to the heights of the buildings would quite obviously potentially affect the landscape and heritage effects, but perhaps not affect the ecology effects as set out in the original. So the original EIS would still be deemed to be up to date for that. Even within topics, not all elements of that topic may be relevant. So, for example, if you were seeking to make a change to the drainage design of a development, it kind of follows that that might affect the assessment of the development in respect of newts, but it perhaps wouldn't affect badgers. So if you were providing an updated ecology chapter, you could scope some receptors in and some receptors out. So we would obviously encourage our developer clients to go through this process with the local authority, and we would encourage the local authority to take a pragmatic and proportionate approach to the scope, thereby making sure that no one is preparing undue levels of information and making the process any longer than it strictly needs to be. So once you've prepared a supplementary EIS, the regulations set out how that should be advertised. It's a 16-week decision-making process, and crucially, everyone who received a copy of the original EIS needs to be sent a copy of the supplementary EIS. So you can't just send it to specific consultees who might be interested in the change. It needs to go to everyone. Finally, there should be a new non-tech summary prepared, and that non-technical summary should be a summary of both the original EIS and the supplementary EIS, covering both documents. Thank you. Next slide, please. So I'll now move on to the topic of salami slicing and the recent case of a bridge to nowhere. So some of you may well have heard of salami slicing, and it is essentially dividing a project into parts so that the effects of each part are not significant and EIA can be avoided. A key legal test in this is whether there is a clear intent on behalf of the developer to avoid the need for EIA. And case law has set out that this is not lawful. Next slide, please. So a recent example from earlier this year related to the construction of a bridge. And this was coined by the local community as the bridge to nowhere. Now, the bridge was just that and only that. It was a bridge with no connecting roads over a railway. The purpose of the bridge was to unlock land for phase 1 of development, which comprised 800 homes in a garden town, and that garden town then included 10,000 homes. Planning permission was sought for the bridge due to immediate funding being available for it. Next slide, please. So what are the key points arising from the case? Well, it was agreed that the bridge was Schedule 2 development for the purposes of the EIA regs, and the council should have considered the future garden town development when screening the bridge. They were wrong to disregard it and consider it on its own. The council should have asked themselves, what is the project and would likely significant effects arise from that project? In the decision to approve the bridge, the officer's report advised the committee to take account of the benefits that the bridge would deliver, namely linking and access to 800 homes to be provided in the future, but that they shouldn't consider any of the harms associated with those houses, saying that the concerns of the houses weren't material to the determination of the bridge application. The court said this is irrational. Clearly, both benefits and harms would be realised if the bridge was constructed. There should have been a discussion on whether the bridge was functionally interdependent and whether it was an integral part of the master plan for the garden town. The planning statement, which was submitted as part of the bridge application, stated that the bridge was critical to unlock parcels of land. It therefore follows that you needed to consider what is happening on those parcels of land. Next slide, please. Now, the Borough Council's position was that there wasn't enough information on the wider master plan and it was too nebulous, and the EIA of the houses would be undertaken at a later stage. However, the court said an assessment should have been carried out, but recognising that some elements were not yet certain, again relying on the principles of the Rochdale Envelope, which we touched on a little earlier. The court was concerned that if you didn't deal with the wider project, it would mean that developers would essentially conceal plans for larger development and bring them forward in a very piecemeal way, and this would defeat the entire purpose of the EIA regulations. Essentially, the case emphasises that where parts of a project are uncertain, that doesn't mean that there is no project at all, there's no wider project at all. Rather, the decision maker needs to take account of the wider project, but account for the inherent uncertainties in their analysis. Consider whether the development would have any purpose if the other development didn't come forward. And the court also considered that it was irrelevant that the wider project had no formal planning status at the point that the bridge application was coming forward, or that parts of that wider project would be the subject of EIA at a later stage. Thank you. Next slide. So, drawing on this case law, how do you decide what is the project? This list isn't exhaustive. Some points will be more relevant than others. But if you're the decision maker, it's really important to think and come about a reasoned judgment on whether the project in front of you is something larger. The bridge is quite an obvious example. Many more will be more subtle than this, and we realise that it really is quite complex. So the types of things to think about are the whole site in single ownership? And is it being brought forward by a single applicant, but perhaps the applicant has only presented something discrete and isolated? Do you know that they intend to submit multiple applications and not do an EIA for any of them? Are they trying to get a small first phase away and then saying they'll do an EIA for the remainder? Do future phases provide support services to the uses on phase one? So, for example, do later phases deliver a school or shops, and therefore the first phase and future phases could be considered to have functional interdependence? Are there roads in the first phase connecting into the remainder? Has perhaps the consultant team liaised with consultees to agree surveys for the whole site, or a pre-app or a scoping report being submitted for a larger site? Think carefully about demolition. So on sites requiring demolition, would that demolition happen irrespective of any future development? So while the development on its own might not have initially been considered to be EIA, if it's clearing the way for a development which would be EIA, it would be much more robust to address it as a whole project, assessing both the demolition phase and the later development. So give extra thought to when demolition is included in advance of an EIA. So this is probably one of the most complicated issues in EIA, and it's one that we regularly advise on both internally but also externally to local authorities and developers. If you're not sure about how to go about coming to a robust decision, or if you're not sure that the developer has presented the full project to you, don't be afraid to ask some more probing questions or seek the advice of a specialist. So Heather has ran through the basics. I've gone through some of the more tricky issues in EIA, and now Nikki will go through the way ahead for EIA. Thank you.
Thanks, Gail. Next slide, please. Thank you. We've obviously covered a number of issues here, and I think it was important just to sort of contextualise this a little bit as well. This statistic I always find quite useful. EIA is actually a very rare and exceptional circumstance. It relates to the very largest developments that we bring forward within England, but it is 0.1% of all applications typically are EIA development, and it's important just to contextualise that. But just to remember that the main aim of EIA is to ensure it's a decision-making tool. It's to ensure that as decision makers, all of the information that's available on the significant effects of the environment are fully available, and this is taken into account part of the decision-making process. And that's quite important when we think about the sort of issues that that you're all facing and how this might be taken forward. Next slide, please. But I think it's recognised that there are some strengths and weaknesses of the process. There have been a number of studies. The EU did a study prior to the 2014 EIA directive. There's a couple of images on the slide from IEMA, where they've reviewed various things about the state of EIA in this country. But I think its strengths are it's a robust, consistent assessment of the environmental effects for the very largest projects that we do in this country. And I think the 2017 EIA regulations, from the industry's perspective, implemented some really key improvements as a result of the reviews that have been undertaken, which I've put on the slide. And I think it's fair to say that from the industry's perspective, we think that the process is maturing. The legal challenges are becoming more focused from the EIA process, which I think is the sort of overall perception of where we're up to at the moment, kind of 20, 25 years or so on since the sort of main EIA process that we currently operate was brought forward. But there are weaknesses. It has been highly litigious. There's a lot of EIA case law, which I think everyone's very, very aware of. People tend to be quite risk averse, which can lead to issues with unnecessary assessment work or an inability to change because people want to use the processes that they're familiar with. They are relating to the very largest developments that we do within this country. So yes, they do take time to pull together. They do cost developers to pull together an EIA, but they are the very largest developments that we do bring forward. They can be complex. Some of that is presentational, but they can be complex. I think there's a question about how much they're actually read. Is quite important, whether they're just sort of pulled to pieces as part of a consultation process and dispatched. They have a bit of an image problem. I think people tend to groan when you say EIA to them, which I think can be unfortunate because they have got a really important role. And I think the relationships to other forms of environmental assessment is also quite important. Things like habitat regulations assessment, which I know a lot of authorities are grappling with, and also EIA's sibling assessment. Next slide, please. Which is the knotty area of strategic environmental assessment, which I'm just going to very briefly mention it because it is relevant to what I then cover. This relates to the environmental assessment of plans and policies, and it makes sure that environmental considerations are taken into account when you're bringing forward those types of documents. But they have had some problems. They have led to planning delays because of the poor implementation of the quite complex legislation relating to strategic environmental assessment. There has been some inconsistent implementation of how the assessment is then applied within policy documents. There's been accusations that it's just a box-ticking exercise. They can be very lengthy, very impenetrable. Availability of robust data to make sure that the EIA, the SEA is done correctly at the time of preparing your policy documents are sometimes not available. And sometimes the skills and resources are not available within plan making authorities to be able to pull together the document robustly. Next slide, please. So I think together, EIA, but also SEA, I think these are some of the words that typically you see when you're talking about these processes. Complicated, there's delays, lengthy documents, they're causing problems, unclear what you do with them. These are the sorts of typical issues that you see arise. Next slide, please. And the government have been trying to address this, and there was a mention within the Levelling Up and Regeneration Bill. It was just a mention to the potential to apply specified environmental outcomes, which is this new process for potentially dealing with environmental impact assessment within England. Next slide, please. And then further detail has been provided in March this year, which was a consultation paper called A New Approach to Environmental Assessment, which was brought out by the Department for Levelling Up Housing and Communities. It was a consultation paper. There's still quite a lot of detail that is missing in there, but I think what the stated objective of it was that having left the EU, there was an opportunity to pull us away from the EIA directive and come up with a solution that works better within England. Next slide, please. So the key headlines: the consultation period on the paper ran from March until the 9th of June this year. It is very high level. It is quite politically worded, and we're waiting really for the draft legislation to provide us with some more detail about the precise detail of some of the proposals in there. But I think the important element is that it's proposing a new single process that will replace the entirety of strategic environmental assessment and EIA, so a single process, consistent process relating to the both. But there were three sort of key aims and objectives which it sets out, which was to retain the current rigour of the current process, obviously emphasising the importance of ensuring that environmental effects are properly assessed, to create a tool that helps to speed up decision making, and also to help communities understand what those effects are. So those are the kind of three key objectives that the paper set out. Next slide, please. Thank you. And these were obviously picking up, I identified a few limitations that we know within the industry in relation to the EIA process, but these are the 5 that are identified within the consultation paper. It talks about inefficiency and the need to ensure that assessment is carried out at the right time. It talks about duplication, and that there is a number of different exercises that are perhaps doing a similar type of process, and the need to kind of bring them together and avoid duplication. There's a need to tackle the issue to do with risk aversion. The litigious nature of EIA over the last few years has obviously caused some issues, but there is a concern that this has led to inaccessible and unwieldy documents, to try and address that. Fourth one is then to create a better sense of focus, that to ensure that it is properly scoped to some of those issues that Heather was picking up on earlier on. And the final one is then issues with data. I think this obviously relates particularly to the strategic environmental assessment side, but I think it's sometimes relevant to EIA as well. But it's just ensuring that that relevant, accessible data is available to ensure that people can conduct the assessment appropriately. Next slide, please. So the proposal that's set out, and like I say, there is very limited detail at this stage about precisely what this will mean, but the suggestion is that agencies will identify desired outcomes against a series of environmental topics, and the assessment process will then measure at a high level the effects against those outcomes. There's an example that's cited within the paper to do with biodiversity, and it suggests that an outcome that we might be seeking to achieve with the environment is an increase in the abundance of protected species. And then it identifies strategic level indicators. I suspect probably that's how you would assess your policies or plans against, which is whether or not what you're planning, your policy changes the status of protected species and supports habitat across an area. And then project level indicator, so that's if you're bringing forward a particular development. Again, a similar thing against that sort of indicator and demonstrating how you're addressing that particular outcome. Next slide, please. So what would assessment needed and what would it look like? Very simply, there is reference to screening and scoping within there. Screening, again, there is limited detail, but there is a suggestion to minimise ambiguity and make it a lot clearer as to when an EOR would be required. Scoping process, actually, they try and do away with that by suggesting that the same environmental topics are covered within each environmental outcome report. The topics identified, just very briefly, were biodiversity, air quality, landscape and seascape, geodiversity, soil and sediment, noise and vibration, water, waste, cultural heritage and archaeology. And the suggestion is that each environmental outcome report would assess all of those different topics. You wouldn't have a sort of scoping in and scoping out process. There's some interesting omissions which I think have certainly been picked up. Social impacts, health impacts, climate change are obviously not mentioned, and that's certainly been picked up by people who've been reviewing the consultation paper. The aim is that the document would be succinct, it was summarised and signpost underline technical work, and rather than having appendices, they would basically be separate and standalone, and you would draw from those. Alternatives and cumulative effects, however, would still need to be addressed in a robust way. Next slide, please. Briefly, some of the other proposals that are set out in the paper. Again, this picks up some of the issues that Heather and Gail have already recorded in terms of the EIA process. There's an aim to strengthen mitigation. There's a focus on embedding mitigation early, making sure that you're using your process, your assessment process properly, and embedding those issues to try and reduce environmental effects. There's also reference to adaptive mitigation as a concept to bring forward, which suggests the potential to monitor how your mitigation is being brought forward on a site. If it's not working, the potential to then go back and revisit that, whether that's by amending planning conditions or something, I don't know. That's, I think, some of the detail that we need to see. But that suggestion is introduced within here as a means to sort of strengthen mitigation. There's a reference to mainstream monitoring and an intention to try and ensure that things are properly monitored. And then that is linked to the collection of data on different environmental facets that will then be stored. This moves on to unlocking data, reporting against performance. There's a reference to local authorities requiring standardised data and actually pulling together the outcomes of the monitoring of how environmental outcomes reports are being brought forward, and storing that data and then reporting back to demonstrate how these different projects are meeting the various environmental outcomes which have been set by the government. And again, a focus on digitisation, which I think is consistent across the planning process. Next slide, please. So just briefly weighing up the proposals, we know that we've certainly inputted into various detailed responses to the paper that have been submitted by the EIA industry. Much is still uncertain, and there is a need really for these additional information that might well be in draft regulations to understand exactly what how this will all work. I think the commitment to retaining current environmental statements and embedding mitigation must be supported, as well as the greater digitisation and the focus on more focused documents. I think we would certainly support that. But I think there is a need to ensure that the approach is not counterproductive. I think certainly with EIA, I think, as I mentioned earlier on, the process has become quite mature. It's working quite well. Some of the legal challenges are becoming a lot softer, and what we don't want to do is sort of go back to the beginning almost with that and suddenly create a new system that becomes a lot more litigious. So I think that's something that we need to try and avoid. Next slide, please. So this is just my final slide. I would love to be able to offer you some solutions to how we deal with some of the issues that I know are all challenging you in terms of EIA, but I just wanted to pick up on these 6, some of which I think are coming through from the consultation paper, but I think some of the issues that Heather and Gail have picked up on earlier on. These, I think, are the sort of a summary of probably the 6 key things that are probably, in terms of decision maker and applicants, are important for us to have a look at. Resourcing, I think, particularly in terms of decision makers, I think this is a key one. And I think, as Heather mentioned earlier on, using PPAs, if you're a decision maker, can help to ensure that you've got proper resources to review environmental statements. Digitisation is coming, and I think just ensuring that you've got appropriate systems in place to be able to deal with if EORs are brought in, this complex data, storage of data, but also just thinking more generally about, do you need that paper copy? As the industry, we're all desperate to try and use new solutions to how we present this information to make it a bit easier and clearer for people to understand. Just focus on some of those issues. Skills and expertise. Do you need an expert to help you interpret the ES or carry out the process? Identify training needs as early as you can. Ensure that you've got the right people involved. Outcome delivery. This really is sort of focusing on mitigation and monitoring. If you look at nothing else with an environmental statement that's in front of you, look at that mitigation and monitoring and making sure that that is translated to your planning permission. That's really, really important. That's the sort of, it means the EIA has got a useful purpose rather than just being a lot of documentation. Be proportionate. Be bold, avoid this kind of risk of throwing the kitchen sink at projects. And I think finally, just a consultation for those who are risk averse, making sure you remember that the EIA is effectively, it's a consultation, it's a decision-making tool, making sure that you are doing that in a timely manner and that you're engaging with the right people, and that feeds into the process. So I think all of those together, I think what is just important to remember that what we're doing here is to try and ensure that this process, it can be a little bit fraught with risks and concerns, but the main aim really is to try and ensure that environment is given a proper part in the decision and the planning process, and it's got a really important role as part of that. And I think that sort of takes us full circle back to Richard's introduction and the sort of main Homes England objective, which we're looking to address this morning, which is about enabling sustainable homes and places. So it's making sure that environmental consideration as part of sustainability is fully taken into account. And that was me. Apologies, we've gone a little bit over. If we want to move on to questions.
Cool. Thank you very much, Nikki and Heather and Gail. I saw lots of claps and thumbs up from the audience there, so thank you. So yes, as we collate the questions together, I've got one prepared for you to start with. So yeah, if you turn your cameras and microphones on, the presenters. So I'll start off. I think this one's for yourself, Nikki. So here it says, on large sites, it's often not as simple as putting in a single application and development, and the development is naturally brought forward in phases or via drop-in applications later, or you might want to demolish something before an application is submitted. What are the environmental impact assessment issues here?
Yeah, sure. I think this probably touches on a lot of the issues, and certainly Gail's presentation as well. What is the development? I think one of the questions that we quite often get asked is, how do we structure the planning process to deal with the EIA? And I think the reverse is true. Where's your red line? What is it you're wanting to do at the moment? Is it demolishing a building? Is it a first phase of something that might be a larger scheme? And I think it's important to make sure that you're very, very clear on what that is. What are the effects of that, and can that be brought forward on its own, or does it relate to a larger whole? If it doesn't relate to a larger whole, what can you reasonably do at the moment? What is it that you can assess? It's important that the EIA is carried out as early as you can, where you're able, based on reasonable information. So I think it's twofold. It's thinking about your development, it's thinking about the relationship, it's just making sure that the EIA is done at the appropriate time. I think it's important also just to make sure that you're being proportionate. I think Gail's Bridge to Nowhere is quite an interesting example. I mean, it's quite clearly that has got a role as part of a wider development, and there was a clear need to ensure that there was that was fully understood. But equally, there wasn't a need to do a sort of an all singing, all dancing assessment of the wider scheme that we brought forward in its entirety, because that's reasonably not available at this stage. But there was important to make sure that cumulative effect was appropriately reflected upon. I don't know if Gail, there's anything else you wanted to pick up on that?
No, I think that's pretty good. Happy to move on to the next question.
Thank you very much. Yeah, so the questions being collated. So I got about just under 15 minutes for some questions here. So I think the first question came through when you're doing your presentation. Heather says, can you clarify the competency elements of an environmental statement?
Sure. Yeah, thanks, Richard. This is a good question. Something that was brought in the 2017 regs, and it's really to ensure that people undertaking the assessments in the ES have the professional competence to do so. And the way that this is addressed in our ESs is that we have a short section about the author in each technical chapter, and at the beginning of the ES about the EIA coordinators. And what we tend to look for is usually people have got some kind of professional membership of a professional body, and then they'll state the number of years experience they've got in EIA development. And at Lichfields, we are members of IEMA, which is the Institute of Environmental Management and Assessment. And we have an IEMA quality mark on the front of our ESs, and a lot of other consultancies do the same. And that provides assurance to developers and local authorities that the people at Lichfields working on the environmental impact assessment have the necessary experience and expertise. I don't know if, Nikki, you want to add anything to that?
Yeah, I think the key thing, this is quite an interesting thing when it was brought in under the 2017 EIA regs about how this would be brought forward. And actually, to my knowledge, it's certainly never been legally challenged, which has been interesting. And it's really about the developer ensuring that they've got the right people on the job, and we help them do that, certainly on the environmental statements that we're involved in. But it is worthwhile just making sure that that there is reference within there that that process has been undertaken. So there is a very clear statement within environmental statements that it has been properly done, that we understand what the qualifications and the accreditations are, those who've inputted into the process. But I think also on the flip side, from the local authority, to ensure that you've got people who understand what they're doing when they've got an environmental statement in front of them, and that they know what they're looking for, to ensure that that competency in terms of decision making is also in place.
Thank you very much. I think move on to our next question. This also came through during your presentation, Heather. It says, I think they're clarifying, just to clarify, scoping opinions are not mandatory, but screening opinions and environmental statements are, if it meets the definitions of a environmental impact assessment development.
Okay, so it's not mandatory to seek a scoping opinion, nor is it mandatory to seek a screening opinion. However, there is a duty on local authorities to screen all Schedule 2 developments, and they should keep a copy of their screening decision on Part 1 of the register for any subsequent planning application. However, if a screening opinion is sought, if a screening request is submitted, then the subsequent, sorry, I said screening and I meant scoping. This happens all the time. If you do seek a scoping opinion, then the scoping opinion does become mandatory in the sense that any ES prepared subsequent to that has to adhere to the scoping opinion. So I hope that answers the question. Sorry for jumbling my words a little bit there.
That's okay. All similar words, aren't they? That's great. Thank you very much. Cool. And I think this next question sort of popped in when you were doing your presentation, Gail. It says, who is responsible for monitoring mitigation?
Well, ultimately, I suppose the monitoring comes down to essentially I suppose a double effort between the local authority and the developer. Obviously, if there is a requirement for a monitoring condition, that needs to be very precisely worded. You need to be really clear about what level of monitoring needs to be undertaken and how long for, what information you're expecting the developer to submit, and then ensuring that they do that. Ultimately, I suppose it becomes an enforcement issue, but obviously it's all set out in the terms of the planning permission. So it is enforceable, but I suppose it comes down to the specifics of exactly how the condition is worded and exactly what the developer has submitted under that. I don't know, Nikki, if you want to add anything.
No, I think that probably picks up the point, Gail.
Yep.
Cool, thank you very much. Another question here. It says, do you think environmental impact assessments and environmental statements will be extended to smaller developments in the future?
I think this is an interesting one. I think there's certainly, dealing with IEMA, there has been reference, and certainly there has been practice about bringing together smaller environmental reports, which adopt some of the same processes as formal EIA, but what it does is it brings together and aligns and ensures that consistency and approach between different types of environmental statement that will be done anyway for any type of planning application. And I can see merit in it, in a sort of a go-to one-stop shop for picking up the environmental issues, and certainly where I think, as we try to emphasise in this, that we remember that this is a decision-making tool. If it's doing the same with smaller developments in helping to guide decisions and planning consents and planning conditions and making sure that they are properly taking into account the effects of the environment, I can see that that would certainly be a good thing. So yes, there is informally, I've certainly seen that being something that is coming forward, but nothing formal yet. And I don't think there's anything in the EOR consultation report certainly to suggest that they would do that.
Okay, thank you very much. I've got a question comes in here. I think you may get asked this one quite a lot in your day-to-day role. It says, is it okay to upload environmental statements to the website, and then you give the option for people to contact the agents and pay £50 for a paper copy of an environmental statement, rather than making a reasonable number of copies available in a specific location? And is it okay to serve the Secretary of State with a notice via email and a WeTransfer link containing the environmental statement rather than the full environmental statement?
This is an interesting thing. What is a copy? And I've seen, I'm going to be absolutely honest with you, different legal advice from different lawyers on this one. A copy can be interpreted as a paper copy, but obviously we are a planning system that is moving towards greater digitisation. I think certainly from our perspective as producers of environmental statements, we would aim to provide digital copies, and I think that's really the way that people want to review things nowadays. I think certainly if you've got the systems available, and again, remembering that key focus of anything here is ensuring that people have got the information that they need. If that's available digitally and it's easily accessible for people, personally, I don't see the issue. But I say it's always been a bit of a knotty thing. What is a copy? Certainly the regulations don't refer to paper; it refers to copies. And it's I say we have a number of discussions on that particular topic.
Well, thank you very much. Here's a question here. Someone possibly came in for relates to your presentation. Heather says, can an applicant question the council's scoping opinion, i.e., query the council on additional topics they should consider to be scoped in?
Thank you. Another good question. There is provision in the regs to seek a scoping direction from the Secretary of State. However, in our experience, we would usually recommend continuing liaison with the authority if you don't agree with something in their scoping opinion, or you might want to have communication with them because something about the development has changed that wasn't in the scoping request. So there are various reasons why you might want to continue discussions with the local authority, and we do if we do that and change slightly the scope of the ES, then we would always append copies of that communication into the ES, so that there is the chance to do that, although the way you do it kind of varies case by case basis depending what you're wanting to query and also the relationship with the local authority.
Cool. All right, thank you very much. No other questions? Quite a lot of questions today. So here, will there be no longer an assessment of the social and economic effects of plans and programmes within the environmental outcomes report, which is what the sustainability appraisal process currently covers? Is there an estimated timeframe for when the environmental outcome report will replace the SEA/SA regime?
Yeah, those are really good questions. I think certainly Gail and I engaged with a number of professional bodies who responded to the paper. One of the questions that was asked was, how long is this going to take? When is this going to come in? And I think the recommendation that has certainly been given from the representations that we've seen is that we should give as long as possible, because this is a completely different process to the way that things are currently carried out. So I don't think it's going to happen tomorrow. Certainly, if it is brought forward, there's a need to obviously get some regulations out in place. So I think in terms of timescales, we don't know yet, but we'll keep an eye on that. And I think the industry is keen for as long as possible. Social, economic health issues, I agree. And I think certainly, again, a lot of the response that we've seen from the industry is a concern at that falling away, both from an SCA and also from an EIA perspective. The proposal seems to be that this can be picked up appropriately through other means within an application, but I suppose the importance of that as a receptor and ensuring that that's dealt with properly and robustly, I think is a concern. And I know a number of people within the industry have given the same feedback. So again, we'll see how that one rolls out.
Thank you very much. I think I've got time for a couple more questions. So it says here, what is the difference between a habitat regulations assessment and an environmental impact assessment?
Do you want to do that one, or do you want?
I was going to suggest Gail did it because she did a recent internal on that.
So essentially, the habitat regulations assessment has its own set of regulations, and it is a separate process to the EIA process. However, it is important that both are integrated. So when you're doing an environmental impact assessment and the scheme also requires a habitat regulation process, the two things should be making the same assumptions. It should be dealing with mitigation in the same way. But ultimately they are two processes, and we would often suggest that the habitat regulation assessment is definitely appended to the EIS, and indeed there should be a section of the ecology EIS chapter which deals with the HABS regs assessment. So integrate them, but they are two separate things and they both need to meet their own individual requirements under the regs. Don't know if you want to add anything, Nikki or Heather.
No, I think that probably covers the point.
Richard, I was going to answer question 17 if that would be useful.
Yep, I can. Let me read out that. Yep. So It says, can an environmental statement addendum be considered alongside a Section 73 application submission, or does the 16 weeks and decision need to be run before the Section 73 application submission?
So obviously a Section 73 application is an application to vary or amend a development, either normally by way of varying some plans or varying the specifics of the planning conditions. So it is a Section 73 to an EIA development, and once you are EIA development, you will always be EIA development. So that section, so if there was an ES for the original application, the Section 73 application must be accompanied by an environmental statement. Now, picking back up on my slide about supplementing the EIS, the question you need to ask yourself at the time of the Section 73 is the original EIS still sufficient? And if it is, the Section 73 application must be accompanied by a copy of the original EIS. So what we normally do is fill in the form for the Section 73 and any other documents that we're submitting and provide a WeTransfer link of the original EIS, and we would explain in our cover letter to the council why we feel that EIS is still sufficient for the purposes of the Section 73 application. If it's not, we would then submit an addendum to the environmental statement or a supplementary EIS. So it's not something that happens before, it's something that happens alongside and as part of. And if you get a Section 73 application for an EIA development, there must be a copy of the original EIS, and that EIS must be uploaded as part of that Section 73 application and consulted on. So it's one that's often forgotten, but it's a really important process stage to remember.
Okay, thank you. I think the last question here is sort of related to your answer there. It said, would a new Section 73 application to vary an old permission that was considered against 1999-2011 regulations be considered against the 2017 regulations?
You want me to pick that one up?
Yep.
Yes, in short, and I've done this very recently, so I can answer with certainty because we've had legal advice from various lawyers on this one. Because the regulations have effectively been revoked, the robust position is to ensure that your Section 73 is being considered against the current EIA regulations, the 2017 EIA regs. That doesn't mean there's a need to panic. What we've done in this kind of situation is to ensure that, for example, things like the competency test, which are now being brought in the 2017 EIA regs, to make sure that our addendum is picking up that to ensure that we demonstrate that we've got a competent team involved in assessing the implications of the 73 proposals. So hopefully that's a very simple answer to that query.
Cool, thank you very much. I think we've run out of time for any more questions. So I'd say thank you very much to Heather, Gail and Nikki for your presentations today. They're very, very informative. Hopefully the audience found them very useful. And so that's a good presentation. Thank you very much, Julie Fields, for the time. Thank you for everyone to attending.
Yeah, thank you very much.
Thank you.
And have a good day. So, goodbye, everyone.
Bye.
Bye.
Hey.